here we have, that's the main thing that is a little bit problematic of the UPC. You have very short deadlines, and it's very hard, based on the case law we have so far, it's very hard to get an extension of term. So normally you have to stay within. So imagine you will get an infringement action, you're a small law firm, and you have only 3 months to do everything until you file your writ in defense. And that's very, very short term, because you have to inform your client, you have to discuss about which lawyers you use. If you're just a patent law firm, you have to look for a lawyer. And so this may be, and it turned out to be very short. And overall, as the statistics shows, the UPC courts managed to keep 1 year. That's what they had set at their target. They want to have set to reach a decision within 1 year. And that turned out quite realistic. So we have, in the average, I think we have between 12 and 15 months for an infringement case, which is very short, because it also covers validity. And that was a problem with the bifurcation before in Germany. You had the infringement decision after about 1.5 years, but the German patent court took about 3 years for the validity. And that was the so-called injunction gap. So the patentee could have got an injunction, and the defendant had to wait 3 years until he could do something. So that was a real problem, and that especially in preliminary injunction cases, because he was thrown out of market. So that is a good, but we have an interim procedure. This is quite helpful. So after the first written procedure, we have an interim procedure where the judge rapporteur discusses with the parties whether there's any option for settlement, and this is a specificity of the UPC, and then we have the final oral proceedings with decision.